Good health to you all. I'm going to speak today about conglomerate mergers and the potential competitive effects of conglomerate mergers as seen from the United States and, in contrast, the European Commission and individual EU states. So basically what I'll first do is I'll talk about conglomerate merger actions in the European community. Then I'll speak in contrast to what's going on and has gone on in the United States. And based on that, we'll talk about some competitive effects that can arise with conglomerate mergers, and in particular, digital platform mergers, which are being studied and discussed quite a bit these days. So let's start with what's a conglomerate merger. There are two merging firms that do not, and I mean not, make directly competing products, and also do not make inputs that are used to produce the other firm's products. So not a vertical merger, not a direct horizontal merger. So there's no immediate loss of direct competition when we're discussing a conglomerate merger. Now, the European Commission has a history of investigating and challenging and sometimes preventing or putting conditions on conglomerate mergers. There have been at least 9 challenges since 1997. And in addition, in 2008, the EC produced a set of non-horizontal merger guidelines that included a variety of potential theories of competitive effects from conglomerate mergers. And here's a list that others and I have put together from those actions. So you can see at least moderately active. On the other side, there's the US. The US was, at one point in time, interested in conglomerate mergers. It went and challenged 11 mergers in 10 years back in 1964 to 1974 at a rate higher than what the EU's been doing in the past 20 years. But there have been no challenges of a pure conglomerate merger after 1974, except for some specific potential entrance cases, drugs coming in who were anticipated but not on the market yet, sort of things, and innovation loss type mergers. Up through 1994, from 82 to 84, there were non-horizontal merger guidelines that really weren't changed. They focused on 2 areas, not the general areas of concern for some conglomerate mergers about portfolio effects and bundling particularly, but about eliminating specific potential entrants and about vertical mergers. In this year, 2020, the vertical merger guidelines have been drafted and to replace the old 4.2 1984 vertical merger guidelines, to update them with more current theories and practice. When they withdrew the old non-horizontal merger guidelines from 1984, didn't do anything in particular with the elimination of potential entrants, and certainly didn't discuss conglomerate mergers. And these mergers over this period of time, in general, you can find, and I won't go through this, you can look through the background materials, but McDonnell Douglas and Boeing merged, and in effect the EC in part challenged it on a conglomerate theory, and the FTC investigated nothing. General Electric Honeywell, once again, the same type of thing, although there were parts that were horizontal that the Department of Justice in the US changed. Tetra, Laval, and Seidel, once again, very similar situation, although the courts were not necessarily endorsing and didn't find conglomerate merger of anti-competitive effects, but didn't throw them out either as a possibility. Same thing is true on Broadcom Brocade as recently as 2017. Once again, an area where the EC was concerned, took action, got some relief, and the FTC chose not to pursue. The US position is probably best summed up by recent comments from the American Bar Association Antitrust Law section, commenting on the draft vertical merger guidelines for the US. And it's a quote out of their comment. The vertical merger guidelines need to be revised to explicitly state that the agencies do not recognize conglomerate effects as a theory of merger harm. It goes on to say the theory of competitive harm, it depends on highly attenuated change of causation that invites competition authorities to speculate about what the future is likely to bring. In other words, it requires a series of actions that the ABA antitrust section does not believe can be reliably analyzed. So let's think of section. What do digital platforms create new concerns, either in the U.S. or in the EU? Well, let's talk first about what is a platform. A platform connects two or more distinct groups of consumers, such as credit card companies in the Amex case. It creates valuable interaction between users by reducing transactions costs. They have typically some cross-network effects, or at least indirect network effects. That is to say, by building up one side, it creates demand to use the platform on that side, and in fact, also on the other side of the platform. Also, the platform can set prices and other conditions to users of each side of the platform that will affect the transaction numbers and the number of users that are engaged. And some examples in particular of digital platforms would be Google, Facebook, Microsoft, and Uber, but also others such as credit card companies, and as I said, for Amex, the recent Supreme Court U.S. Amex case. So let's think more specifically about what digital platforms have that could result potentially in anti-competitive conglomerate mergers. First, they typically have economies of scale. The more people served, because it's a high upfront expense, the less cost per person as you add more people. Low marginal cost. The additional costs tend to be small to add people or businesses. There are economies of scope. You can have even if you're serving two different markets, if you have information on consumers, you may be able to serve them in terms of instant messaging better, but also in terms of targeting advertising. Ability of firms to incorporate ties into their products design. This goes back all the way to Microsoft trying to disadvantage some potential competitors back in the 1990s. There are direct and indirect network effects, similar to what I've just described. And there are complementarities with other products and services. For example, if you had an instant messaging, such as WhatsApp, that would go and be helpful to and complementary to perhaps social media, such as Facebook. There could be complementarities there. And finally, that these firms have large shares in at least some markets, potentially leading to market power. Now, to show that people are concerned about these attributes of digital platforms, there's a lot of research and there's a lot of policy and opinion papers out there. But one that I'm just going to use this one as an example of people who are concerned about digital platforms and what they may or not be able to do. And this is by the Competition and Marketing Authority of the UK, which came out last year. And I'm quoting out of this for the different sections they have. But some of the interim conclusions they've reached is Google has significant market power in general search. Google has extensive default positions, which helps maintain that market power. And there are scale effects not only on the search side, but on the advertising side using search engines. So Google is targeted as a firm that has potentially the ability to engage in anti-competitive or anti-consumer actions, and to the extent that it does, that could include conglomerate mergers. So the same report discusses Facebook at length, and it concludes interimly that Facebook has significant market power in social media, and the network effects act as a strong barrier to entry and expansion into social media, as well as other services that Facebook offers. Now, this is This is current. There were 77 submissions of comments through April 8th on the interim report, and the final report is due out not yet until into July. So this is very much a current issue, and would affect, these findings could affect whether a conglomerate merger would be allowed by either Facebook or Google. So I'm going to briefly go through and highlight some aspects of the theories of potential harm from conglomerate mergers, and I'm going to point out that these are all theoretical papers based on, and not much empirical work to back up the concerns. So first of all, there's some common elements to these anti-competitive theories. First, there's obviously an absence of effective competition in one market with a barrier to entry, so market power presumably. Economies of scale and scope or network effects in the other market, that is to say, you could take advantage of another market by building up sales and expanding, helping create a barrier into your primary market. And there are two two general groups of theories. One is unilateral effects theories, which I'll talk a bit more about. And these mean that all of them mean that the merger leads to some efficiencies that provided an advantage over single market competitors. And then secondly, by using those advantages, can significantly disadvantage and exclude rivals from one or more markets. There's also the concern, which I'll talk less about, but it is in some of the cases that we need to go back and look, about coordinated effects. And those are concerns about cross-market information sharing that could reduce competition across 2 or 3 different markets. Also, we could potentially make it easier to monitor and discipline any tacit collusion. So that's the information side. But I'll let, like I said, the earlier cases discuss that. Let's focus on the unilateral effects, which is the first one, the bundling and envelopment theories. These are theories that point to the foreclosure of rivals by disadvantaging a single market competitor or potential competitors. And in effect, you can have something like what's called the Cournot effect, which allows a producer in one market to price lower than a single market firm initially, drive that firm out, and then take over the market of the single firm, or at least prevent a firm in that market from entering the market where the firm has dominant position. Now, one thing to keep in mind in these is that these will not only have a potential for anti-competitive effect, but the base move here typically revolves around cost advantages or product advantages that would benefit consumers and then only later have a negative and anti-competitive impact. So now another is the access to key inputs and components. And the idea is that a control over a component may impede entry into any market, and it could be a key component in one market or both. And the key here to remember is that this is theoretically possible, but it requires a firm to provide, but if you want to fix this, you would have to require a firm to provide access to a specific resource that was useful. And in doing that, you help discourage the firm from developing that key resource, which could have a negative impact on innovation. So once again, there's a balancing there to take into consideration when challenging a merger that is a conglomerate. Another one is preemptive acquisitions, and I'll just give one example of this, which is the killer acquisition, which we read a lot about in much of the press. The killer acquisition is when a dominant firm in one market acquires a new entrant in another, a potentially related market. And that would be, for example, should the antitrust agencies have been more concerned about, than they were in the US at least, about, for example, Facebook acquiring WhatsApp. Was WhatsApp going to be able to challenge Facebook? Well, maybe, maybe not. But the question and the alternative in terms of innovation that one needs to balance is if a new, smaller, innovative firm such as WhatsApp, would they have even done what they did if they didn't have the ability to be purchased by someone who could make fuller use of us such as Facebook. And once again, just very briefly here, we have an instance where the CMA highlights some of these issues about the expansion and the market power of Google. They do the same with Facebook. So once again, very active, very big concerns about the necessary conditions without necessarily saying that a specific corporate and conglomerate merger wouldn't necessarily be. So let's wrap up with conclusions here because I've gone a bit over time. One is that the EC is modestly active in engaging and challenging conglomerate mergers, as the history of it, and there's no particular reason to think that's going to change. It seems to be that the EC has a concern over type 2 errors. It's more active than the US in part because it's more worried about a merger that has an anti-competitive effect, but they would let it through incorrectly. Another is that the challenges to mergers are based on, so far at the EC, have been based on a lot of theoretical economic models, and they are consistent with those models typically. Next, the digital platforms have many of the necessary conditions for raising these concerns, as we've sort of quickly summarized. And finally, the policy initiatives that are investigating the need to target digital platforms and could very well have some impact on merger policy, at least regarding to digital platforms and conglomerate mergers, and that they may be more active than they have been in the past. The US is not challenging conglomerate mergers. Now, why has it not been? In part because of concerns over type 1 errors. That is to say, they're very concerned about an otherwise merger that provides efficiencies but doesn't create significant antitrust or competition problems. They don't want to discourage those, so they want to avoid the type 1 type errors. There's a lack of reliable evidence showing that there's a harm to competition from conglomerate mergers. Very little economic empirical work, although a lot of theoretical work. All the theories, though, that exist require some, or at least virtually all of them require some efficiency associated with a merger, some first effect that would be good for competition and for consumers. And only after exploiting that would there be an anti-competitive effect. So there's a longer line of causation, as the ABA noticed. There's little indication right now, at least, that there's going to be a huge change because of the digital platforms, based on what the ABA has said, and looking at what the agencies have done over the past 20 years. There is one outstanding question, though, that I think we all, and perhaps we'll discuss at the conference, and that's what is the policy on acquisitions of potential competitors in the U.S. after the DOJ withdrew its non-horizontal merger guidelines? Does this mean that for conglomerate mergers, that not only will there be fewer of those, but when there's a potential competition case, which arguably is a conglomerate merger in many instances, is the Department of Justice going to pursue any of those? That's a question that we'll know about, hopefully, when we see the revision of the vertical merger guidelines that the DOJ and the FTC are working on as we speak. Thank you, and look forward to our session.